Good afternoon. I am once again joined by Professor Stephen D. Schwinn of the UIC School of Law here in Chicago. Professor Schwinn, thank you once again for joining us.
Well, thanks for having me, Kathy. It's a pleasure.
And this afternoon, we're going to talk about a slightly sad topic. We joined the nation in mourning the loss of Justice Ruth Badger Ginsburg on September 18th. And I think today we want to explore a little bit about the cases that she's most well known for, maybe some that she's not so well known for, talk about her legacy a little bit, and then turn to the future and talk about the potential replacement for her and what that can mean. So Professor Schwinn, just to start us off, any initial thoughts on Justice Ginsburg's legacy, her jurisprudence, what she's known for?
Yeah, Kathy, I mean, where to start? She has had just an outsized influence on American law, and that's an understatement. You can't really overstate the impact that she has had on everything from women's rights to equality more generally, to constitutional law, to elections law, to criminal procedure. She's had her hand in everything. She's most well known, of course, for her path-breaking work on women's rights, both as an advocate and as a justice on the United States Supreme Court, and did some work as an advocate that really set a kind of trajectory for the court's vision of equality with regard to sex equality that endures today. I mean, she put us on the path to thinking about sex equality under the Equal Protection Clause in ways that we just hadn't before the 1970s.
Yeah, one of the things I find most compelling, particularly about her work as an advocate, is she basically flipped the script. And she really took the lessons from those who had been advocating for racial equality and racial equity and took those lessons forward. And it was one of the most creative advocates attempts that she said, we're not going to focus on these laws that actively discriminate against women. We're going to look at the laws that actively discriminate against men. And for me, that was when I learned that about her. I just found that so compelling and so smart and creative. And I know in the commentaries that the current justice has put out, Justice Kagan mentioned how she was one of the most creative legal minds that she had ever met. And that rang so true for me.
Yeah, I mean, you can imagine back in the 1970s when she started to litigate these cases, what you would think is a woman's advocate, for example, would look for cases that discriminate and harm women, right? But as you said, she did in some ways just the opposite. Sure, she was interested in those cases that harmed women, but she was also interested in those cases that harmed men. And what she was particularly interested in, and I find this just fascinating, and again, you've got to kind of put yourself back in a 1970s mindset to, I think, appreciate the significance of this. But she said, by putting women on a pedestal, we're actually putting them in a cage. And so these laws that are designed to benefit women, but not men, were equally suspect in her mind for exactly that reason. Yeah,
it's just a fabulous and such a unique way to attack the problem. Really, really interesting and one of a kind. I know as I was reading some of the tributes to her, some of the women who had served with her at the ACLU just talked about how flabbergasted they were by her approach and the way she really took the leadership on that. And I think, as you said, set the court and set society on a certain path that we see today, and we saw during her time as a justice as well.
Yeah, and so there's been a lot of talk about her jurisprudence, but there's also been a lot of talk, and you kind of alluded to this, about her personal work ethic and her personality and style and ability to work with people, which I just find inspiring and remarkable. She was reputed to be just a workhorse, an unmatchable workhorse, and yet still find time for her family and her friends, and famously making friends across the aisle with Justice Scalia, for example. Just a lot of things to admire about this woman.
Yeah, I was lucky enough through my work with the ABA to see her speak a number of times, particularly to educators. And she always found time whenever she could to speak to any teachers that we had brought to the court. And one of the most meaningful interactions I ever had with her was we had some teachers in Washington, D.C., and her husband, Marty, had passed away on the Sunday, and she was supposed to speak to our teachers that Monday morning. Obviously did not speak to our teachers that Monday morning. but went out of her way later that week on the Thursday to leave the court, come to where we were meeting and speak and spend about 90 minutes talking to our teachers, and just the commitment that she had to making herself and the institution that she represented as accessible and as public as she could. I think it will impact generations to come and how they view the court and how they view the justices.
I think so too, and I like that word accessibility. I think that goes right along with equality. When we read and hear about things about Justice Ruth Bader Ginsburg and the impact that she had both in terms of her jurisprudence and personally on people that she worked with and teachers and students and we the public. Again, just a remarkable woman, a remarkable career. Kathy, she did have some important decisions while she was on the United States Supreme Court. So certainly as an advocate, she sort of set the path for equal protection with regard to sex discrimination. But on the court, she had some important opinions as well. Do you have a favorite opinion?
So I'm going to lean into the notorious on this and actually say my favorite of hers is the dissent in Ledbetter. That closing paragraph in Ledbetter where she says the ball is now in Congress's court. For me, at that point in my career, in working in legal public education, it was just such a fine way to indicate how the balance of power and the structure of our government work, and such a telling push to say this branch of government has done all that it can in this arena, and someone else needs to take the ball over the finish line. For me, that was, I know she's so well known for her dissents, and it's a little commonplace to pick a Ginsburg dissent as your favorite, but that's my thing. How about yourself, Steve? What would be your favorite opinion or dissent, since I took the path
Well, I love what you said about the Ledbetter dissent. And what I so appreciate about that dissent is that she brings in a kind of practical reality to a court that seems to treat the statutory deadline for filing equal pay claims under Title VII of the Civil Rights Act, seems to treat that statutory deadline as some sort of, I don't know, abstract kind of thing where she comes in and she says, no, look, this has real impact in real ways on real women. You can't always establish pay discrepancies within a 180-day period. And it just doesn't work that way. And she brought that to light. She brought it out in the open and helped inspire then the Civil Rights Act, the Ledbetter Act, that reversed that opinion. In a similar way, I think my favorite dissent is in the Shelby County case, the voting rights case, where the court functionally overturned Section 5 of the Voting Rights Act. And she wrote in dissent, look, the idea of taking away this pre-clearance requirement for voting rights, that's a little bit like folding up your umbrella because you're not getting rained on in the middle of a rainstorm, right? Which I think perfectly illustrates exactly what was going on and exactly the problem in the Shelby County case from a very practical standpoint. And I would say post Shelby County, literally within days of that decision coming down, we saw states taking actions that had been held up through the pre-clearance process. And so I would argue that time has vindicated her dissent in that opinion.
And what I think is so interesting about both of those dissents and what we've both said we liked about them or were most compelled by them speaks to what we were talking about her wanting to make it an accessible institution, and that she used language in so many of her opinions, whether in the majority or in the dissent, that was accessible. And that was always a pleasure to me reading her opinions. They were very readable. As someone who spends their time doing editing, a readable opinion makes my heart sing. And some of her opinions, it used plain language, it used similes or analogies that anyone could understand and really see what she was trying to say and understand the implications of the court's ruling one way or another.
Yeah, it's true. And I totally appreciate that as well. And the more we read about her, the more we appreciate that she was a real stickler for language, right? And chose her words very, very carefully. constructed her sentences and paragraphs and opinions with great, great care. And you can see that. One of the opinions that I really love is the VMI opinion, where she introduces this idea of an exceedingly persuasive justification for a state's discrimination against women, in this case in the VMI Academy. And just, that language is just so right on and so perfect and does so much work in terms of advancing equal protection and equality rights between men and women.
Yeah, absolutely. Well, Steve, turning a little bit to the future, we know that President Trump has put his nomination of Judge Amy Coney Barrett out of the Seventh Circuit forward. Judge Barrett is going through the initial steps of the confirmation process. What, in your opinion, does a possible Justice Barrett look like on the court? What are the implications of her taking this seat on the court?
Well, I think we can start at kind of a 30,000 foot level and then work in. At 30,000 feet, you have one of the court's most progressive justices being replaced by what everybody understands as a conservative jurist. And so that's going to swing the balance on the court, change the fulcrum and the medium on the court, and change the dynamics of the court. Kathy, you know as well as anybody the old saw that when a new justice comes on the court, you get a new court, and we expect to see that, but maybe even more than usual when and if we get a Justice Amy Coney Barrett on the court. Zeroing in a little bit more, I think we're going to expect to see changes kind of across the board in the court's jurisprudence. A lot of people have been talking about the right to abortion, for example. I do think that that's something to keep our eye on. Other areas of the law, some people have talked about Second Amendment, for example, another area to keep our eye on. But as we zero in sort of closer and closer to what's going on in the court today, we can take a look at, I think, an immediate concern is the Affordable Care Act and Justice Amy Coney Barrett's effect on the Affordable Care Act. This is a case that's scheduled for oral argument on November 10th. If she's confirmed and takes her seat and hears oral arguments on November 10th, she can be a part of the court making a decision on that case. And given the history of the case and the lineups of the justices, I think it really puts at risk the individual mandate and the tax penalty, which is now set at 0, in order to enforce the individual mandate, which then in turn opens the door to putting the entire Affordable Care Act at risk on the argument that the individual mandate is non-severable. Now, I think that if the court were to go in that direction in the Affordable Care Act case, a Congress that had the sufficient will could undo much of what the court did. So this is an issue that might ultimately rest with Congress, but still, at least in the short term, a Justice Amy Coney Barrett could have a significant impact on the Affordable Care Act. Couple of other cases. Oh, I'm sorry, yeah.
Do you think, and this is something where we're going to maybe see a Chief Justice Roberts attempting to sort of find a balance with a new justice on the court, and he sort of famously saved the ACA the first go at this by finding a way to maneuver some of the words, perhaps, and maybe even doing a little bit of horse trading on some issues. Do you think that this is a possibility on this case, or are we up for a congressional battle and seeing this back on the floor of Congress?
I think probably the latter. In the last couple of weeks, I went back and I looked at the NFIB versus Sebelius case much more closely, and Chief Justice Roberts' decision in that case upholding the individual mandate under Congress's taxing authority. And it's pretty clear that his view of the taxing authority hinges on the government action actually producing revenue for the government. Now, if the individual mandate is zeroed out, it's not producing any revenue. And so I suspect that even under Chief Justice Roberts' view of the taxing authority in NFIB versus Sebelius, I think he very well may say that Congress lacks authority under its taxing authority if the tax penalty is 0.
Right, if there's no tax.
If there's no tax, exactly. And then I think the important thing to watch at that point is the severability question. That's really hard to predict in this particular case. You know, the Obama administration, when they were defending the Affordable Care Act before the Supreme Court, went to great lengths to argue that the individual mandate operates along with as a necessary component of community rating and non-discrimination, that you can't pull these things apart. Well, if you can't pull them apart, then by some reckoning, they're non-severable, or at least that's the argument that we've heard. And if they're non-severable, then those other components of the Affordable Care Act will also go down, but potentially many of the other provisions in the Affordable Care Act could as well, depending on how the court viewed the severability question. Again, I think Congress can undo much of that. They could simply reassess a tax penalty, set it at, you know, something as low as $20, for example, and that would
have something actually be there.
Have something actually be there. That's exactly right. But I think this case does potentially do some serious damage to Obamacare and the Affordable Care Act.
Yeah.
Kathy, you and I know you're keeping your eye on the court docket as well. Are there things that you're seeing coming down the pike that Amy Coney Barrett could have an effect on?
Yeah, so one of the ones I think is also really interesting, which has the potential of having a Justice Barrett hear it in early November, is Fulton County versus the City of Philadelphia, which is a really interesting case about a religious charity and their interactions with same-sex couples who are looking to be foster care parents. And Steve, I will defer to you to sort of give the quick review on this case, but I think it's one particularly with Judge Barrett's sort of known religious life and her deep-seated belief in freedom of religious practices or free exercise practices, that could really have some interesting implications, and you can see her potential jurisprudence as a Supreme Court justice developing here. So do you want to give us a quick recap on Fulton versus Philadelphia?
Yeah, sure. So here the city has a rule that it won't contract out for foster care services with nonprofit organizations that have refused to place foster care children in same-sex couple households. And so a Catholic organization that has traditionally contracted with the city to provide these services has claimed that the city's rule cuts it out of the foster care program in violation of its free exercise rights under the First Amendment, free exercise to engage in religion. And what we've seen, Kathy, is a court, a Roberts court that has been moving more and more in the direction of a robust free exercise clause under the First Amendment, a court that's been moving more and more in the direction of knocking down any wall that might have existed between church and state, and giving much more sort of meaning and weight to free exercise of religion when the government is making what we refer to as sort of religiously neutral laws that nevertheless have an effect on a religious practice. This has been a trend now that we've seen in the court's jurisprudence, and I suspect with the addition of a Justice Barrett, I think we're going to see that trend accelerate. And I think this case may be the one that really sort of puts us over the top and rules for a really robust free exercise clause.
I think you definitely saw it at the end of last term, that you're exactly right, that this is where the court's been going. There was a trio of cases at the end of the term that really foreshadowed, I think, what most of us who sort of watch the court think could have happened in this case in Philadelphia. But with this shifting in alignment, I think you're spot on that it's going to accelerate, that this is, the horse is out of the barn and it's running much faster now.
Much better said, yes, exactly.
Yeah. So
no,
Steve,
I think that's exactly right.
The third case I wanted us to chat about a little bit about the potential of a Justice Barrett is Collins versus Mnuchin, which is another funky, strange case, also a follow-up from last term to some degree, about executive power and agency heads. So can you talk a little bit about this case and sort of what you think a Justice Barrett could mean here?
Yeah, so, and Kathy, as we talk about this case, I do want to put it in a somewhat larger political context. This is a case that deals with a so-called independent agency within the executive branch. And the question in the case is, can Congress create an independent agency within the executive branch that is configured the way this agency is? Well, the court told us just last term that the Consumer Financial Protection Bureau was unconstitutional because it was configured as an independent agency. And so I expect the court to move in the same direction in this case. Now, the larger context here deals with something that we call the unitary executive theory. This is a theory that the president has plenary and unitary control over everything that occurs in the executive branch. And what that means then is that Congress cannot create an independent agency, because by so creating an agency, Congress has taken away that plenary authority from the president to direct unilaterally everything that occurs in the executive branch. Now, Judge Amy Coney Barrett has indicated that she shares Justice Scalia's judicial philosophy. We don't know exactly how far this extends, but one of the things that Justice Scalia was famous for was the unitary executive theory. So if a Justice Barrett adopts the unitary executive theory, not only might we see this particular independent agency fail, but we might see more independent agencies fail. And Kathy, more than that, one of the things that we've seen in the Trump administration is a greater and greater consolidation of administrative decision-making through the White House, what some have called politicizing administrative decision-making. We've seen this everything from the Centers for Disease Control in dealing with the COVID pandemic, to the Environmental Protection Agency and environmental regulations, to DHS and regulations dealing with immigrants, for example. And this is all sort of part and parcel of the unitary executive movement. And so if we see a Justice Barrett join the court, I think we're going to see that trend, again, kind of accelerate. I love your horse and barn analogy. We're going to see that horse running. And I think what that's going to mean is that independent agencies may be going the way of the dinosaur, but more than that, that future presidents are going to see this as a signal that they can more and more consolidate control over agency decision-making through the White House.
Yeah. One of the things I think is so interesting in this area is, in my time in doing this sort of work, we've spent so much time thinking about how do you talk to people about the administrative role and administrative law judges, and how there's this whole decision-making body that sits outside of what we normally think of as courts. And it really feels like there's been a seismic shift in the last little bit where that's no longer expanding in the same way that it did. And I know you've done some writing that's really pushed me to say, oh, I probably need to bone up on this theory some more and go back and revisit some of Justice Scalia's previous decision or his previous opinions, and understand sort of where this could be going, because it seems like there was a big expansion, and maybe now we're seeing a limitation on where these agencies are going.
Yeah, I think that's exactly right, Kathy. And so, it's going to be interesting to see how this plays out, and whether we get any congressional pushback on this, and if we do, whether it's successful in the courts. So, Kathy, let me ask you another question, kind of shifting gears entirely. We're starting to see now a number of emergency petitions going up to the Supreme Court on voting issues coming up to the 2020 election. There are a couple of census cases that are working its way through, and you and I have talked a little bit about how the census overlaps with voting rights and how it could impact the future. What are your thoughts on Justice Barrett with regard to the election?
Oh, that's a great one. I think the ground is shifting quickly on that, because I think that this census case that's currently the emergency petition and the district court judge's order, I think some of that's going to shake out even before we see the potential of a Justice Barrett having some say in things. I think there is, even if her nomination moves at the speed that the administration is saying that they want it to, at least for the census issue, that may be done, or the administration may have folded up and gone home by this point in the census counting by the time we have a Justice Barrett on the court. So I think, at least for the census issue and what that means really long term as it relates to appointments and voting districts, She may not have the opportunity to weigh in on this. I do think we have the potential, if there are challenges to this election, of her being on the court. I'm not familiar with much writing she's done on the issue of elections. This is a court, I think Justice Ginsburg had a lot to say about how elections should be run. Each of the individual justices that have been on the court for some period of time, we sort of know where they stand on voting issues and their deference to states or to the federal government on certain things. But if you add Justice Barrett, that's 3 new judges in the last couple of, or justices, excuse me, in the last couple of years for whom we don't have a clear record, at least when they are on the Supreme Court, of how they play out on voting rights issues. So I know it's a cheap shot to say I don't know, but I think, you know, news changes quickly these days, and there's a lot that's going to happen between now and the time that you would have a Justice Barrett on the court dealing with some of these issues.
That's really insightful. I mean, there is a lot of stuff coming up through the pipeline, and even if she is approved on a fast track, as I think will probably occur, a lot of things are going to happen while she's not on the bench. I do, you know, sort of wonder how much litigation we'll have after Election Day, with in the lame duck session of the Congress, and whether she'll be on the bench by the time she might be able to influence those decisions. You know, it does strike me too that so many of these cases are raising new and novel issues that we just don't really know how the court's going to address them.
Yeah, and you mentioned anytime there's a new justice, it shifts the court. We've had a lot of shifts in the last decade or so. It is an entirely different court. So even if you make connections to Bush v. Gore, it's a totally different court. And there's a lot of tea leaf reading that can be done, but I'm not sure how accurate any of those guesses can be.
Yeah, I agree with that. I still hold out hope that justices will be politically independent in the decisions that they make with regard to the election, whatever those decisions are, and that we don't get the kind of division that we got in Bush versus Gore. I don't think that was really good for anybody.
No, it certainly wasn't. Well, Professor Schwinn, thank you so much for joining us today to unpack the legacy of Justice Ginsburg, to look ahead to the future a little bit. I look forward to our future chats, and stay tuned, everyone. There's lots to come.
Thank you, Kathy.